is in the matter of the extent of personal faith and experience which a person, an individual worshipper has. Well, that is not the area of inquiry. So, when, my Lord, you have judgments which use the words, sometimes you have to find the followers of the faith about the faith. It is not. It is a means of inquiry. It is not, my Lord, to pronounce upon the faith. It is only to ascertain information relating to the tenets of that particular belief. If you view it this way, my Lord, it will be clear that there is cohesion in most of the judgments. But there are two important points. One is the only reason why Justice Mukherjee upheld, my Lord, the Hindu Religious and Charitable Endowments Act was based upon a fundamental principle in Hindu law that the donor's foundation and his benediction and his dedication must be truly honored. That is, all that which comes out of that property must be plowed back. So, my Lord, it was really an evolution of the doctrine of trust. And, my Lord, when they found that the traditional laws dealing with administration of trusts was insufficient, that is, my Lord, breach of fiduciary duties by a trustee, and, my Lord, Section 92, notwithstanding the fact, my Lord, it was there in its earlier incarnation in the Code of Civil Procedure, that it was still insufficient to address the need for the deity to whom a dedication has been made, and that a Shabayat must have honestly, in aid of an endowment, became law principles which sustain this law. But if under the guise of regulation, what was being attempted was actually the management of the temple, then, my Lord, it is completely unconstitutional. So, my Lord, while the Madras High Court in Shirur struck down all the provisions, and, my Lord, there's something interesting in the judgment of Justice Mukherjee. He notices a very special section, Section 92, my Lord, of the 1951 Act, which later became 107, I think, of the 59 Act, which clearly says that no power which will be exercised will interfere with the rights which are granted to denominations under Article 26 of the Constitution. So, my Lord, this is the peaceful coexistence. And when he found that it trespassed on 25(1), or it denuded at 25(1) and could not be justified, even with reference to 26(b), he struck down all those provisions. So, my Lord, I submit with the utmost respect that if we give complete respect to the content of these expressions under Article 25 and 26, my Lord, I think that there will be absolutely no difficulty. My Lord, I just want to show your Lordships just a couple of examples.
There is no need to go into this test of essential religious practice.
My Lord,
an impression has been created that it is only essential religious practice that has to be protected and nothing else.
My Lord, this is, if I may say so, if the judgments suggest, and I, my Lord, personally do not think they go that far as to suggest, that if it is not an essential religious practice, it degenerates into a non-religious practice or will become a practice which is capable of regulation. I do not think, my Lord, any judgment goes this far. But I would submit, if essential religious practice is intended in aid of discovering the true components of that particular religion, then, my Lord, it is assistive in character.
Yes.
That is all. And that can be done, my Lord, by courts. Please feel, my Lord, your Lordships can deal with any branch of law to discover something, my Lord, which is as sublime as religion is not very difficult at all.
Court cannot sit in judgment as to what is an essential religious practice.
My Lord, if I may say so.
Controversy arises out of that.
My Lord, let me
Whether the court can discover or distill and put in judgment.
Well, let me deal with it this way.
You put it this way.
Yes.
The concept of essential practice, as you rightly said, Actually, it exists if they knew to the benefit of either a individual determination or a person or group of persons sitting right in the computer. Right? So, when it comes to divisibility, vertical to the place on a given argumentative exists can be over religious practice. That is why the seems to be in A and B. So,
What is the word religious
for
practice?
religious practice, there's no division. Then as the trying to say, you have to understand what it is. You can still go into it to satisfy yourself by the court on the existence of essential practice, primarily from the point of view of the practitioner or the person who is having to live. So as to exercise your power, the power of judicial review. In this case, it is a little bit more circumspect. What is required by the court, challenge will be only when a law is being created, or if it is not there in the vacuum, that will come only on two occasions. 25(1)(a), when is it made associated with any other practice, secular practice associated. To that extent, we can do where there is no need for essentiality. Because we have to see the individual practice is there or not. If it is there, then it will go away. Then the next one will be 25(2)(d). It deals with the religious practice. Their power can be exercised by the state. In that, the court can go into it, and to caution itself vis-a-vis the existence of a social reform or social welfare. To that extent.
No, I'm very
Yes,
grateful.
put it, if it is for some there, from the point of view of protecting the right given 25(1).
No, I,
Then it should act as a
Yes.
restriction,
Restriction,
or
limitation.
it is only a supporting or an aiding tool for protection.
Malon, may I now read both 25(2)(a) and 26 with you again, Malon, because I think they are very, very, very paramount questions. Please now read with me, Malon, 25(2). Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, Malad, this is a case of a clear boundary between a secular practice and, Malad, a religious practice. They are being juxtaposed, Malad, against each other. This does not pose very much of a challenge, if I may say so. But here, Malad, you may suddenly see that the religious practice which is being invaded is somewhat essential to that faith. Can be. Then you don't have to worry about it, Malad, because it is still a religious practice. It is clearly distinguishable. But let us now come, Malad, to B. B is providing for social welfare and reform, all the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Malad, we will use disjunctive as clause. Let us look at the first one. Providing for social welfare and reform. In social welfare and reform, Malad, there are two important considerations. Social welfare and reform must not be a cloak. That is, it should not be a colorable legislation which actually seeks to invade religious freedoms under 26B. Then in that case, Malad, the law is void. If it is a color, if it's a fraud of the constitution, that is one aspect. The second is, your lordships are asking me, if suppose there is something called social welfare and reform, can it touch upon a religious practice? Can it touch upon an essential religious practice? Now there also, Malad, it is necessary to satisfy the words social welfare and reform. Objectively, there is an element of scrutiny involved by the court to truly examine whether this is advancing social reform or it is your nominee under social reform.
In case of multiple accepted religion or in case of accepted practices, what is the juridical basis on which the court can declare? Whether the court can declare one is authoritative over the other? in case of a dispute arising within the religious practices, accepted practices within the religion.
Well, I will. Can I answer your lordships in two limbs? Because one is the intra-denominational, shall we say, contest about the nature of a practice. My Lord, there are cases. You have the most celebrated case, my Lord, the Badagalai Bengalai, that has been going on for centuries. And I still don't know whether it is over. But my Lord, I'm giving you an example that there can be contests, but those have to be done.
No, you take it, it's not over.
Yes. So, my Lord, in such cases, you will need, my Lord, evidence, you will need proof, you will need to track. But, my Lord, your lordships asked me a more fundamental question. That is the court devoid of adjudicatory power? The answer is, my Lord, the court is not devoid of adjudicatory power. My Lord, there is no other place where any legal rights or legal injury can be established except in a court. I know, my Lord, those are not the, not exactly the ideal kinds of situations, but
so the courts will sit in the armchair of ascertaining the theology of the practice.
my Lord, there will be evidence. And it can, my Lord, may I say again, my Lord, please do not.
So we can take it that 226 and 32 will be barred.
My Lord, in case of a denominational fight which requires evidence, then, my Lord, 226 and 32 may be precluded. But if suppose, my Lord, there is no dispute at all, we can have cases where there is absolutely no dispute on the fundamentals. Then in that case, a question may plainly arise for determination whether this is void or not void.
Vis-a-vis the state.
Vis-a-vis the state. But, my Lord, I have not yet finished with reference to the social welfare and reform. I need to add more. Social welfare and reform. There is one end of the spectrum which is it should not be used for hollowing out or, shall we say, eviscerating a religion.
Yes.
That, my Lord, is no social reform. And for that, the onus is too high for anybody to establish as a state. The second, my Lord, is this social welfare and reform can touch upon a religious practice if it affects or if reform is required. If reform is required, it can touch upon that practice. My Lord, the exclusion of people in temples was justified with reference to anterior texts. Please understand this. This was all justified with reference to some interpretations. But, my Lord, they've said no. They overrode it. And the reason why they overrode it is, again, my Lord, one must never forget that both Mitakshara and Thayabaga schools of law are actually to move away from all those rigors. My Lord, he was the founder of Mitakshara and Chavana Vahatata. Yes, that is for my Lord, Thayabaga. Now, both of them, my Lord, they were actually progressive thinkers who said we must move away from so-called edicts which are written in Smritis and some of them, because they said for the purpose of dealing with present reality, for administering this law, we must have a succinct way, like the Sabinda, as your lordship said. These are all principles which have come this way. So, my Lord, evolution always happens. So, social reform, consistent with evolution and progress, is not, my Lord, an anathema to a religion. But if that religion is substantially being prejudiced, then your lordships have to consider whether it is a direct invasion of 25.1 and also, my Lord, 26. Because, my Lord, 25.1, when it says nothing in this article, my Lord, there are two interpretations possible. One is the extremely learned interpretation for which Dr. Thaban placed, namely, it removes the right and it also removes the limitation. Well, I would say there's nothing in this article is really for the purpose of enabling the state. Well, this is only for the purpose of enabling the state to legislate and to legislate in respect of very restricted matters. So without not these restricted matters and without it being subject to public order, morality and health, the essence of religious freedom under 25.1 and 26 is completely
Subramaniam, so would understand you to mean 25(2)(b is a narrow window of legislative competence vis-a-vis, in accordance with law, qualifying clauses C and D of 26 1C and D, management affair property. That is, any general law can interfere with the right of the denomination to hold and manage the property.
Yes.
But when it is impacting affairs of religion, the legislative competence is to be posited to 26(2)(b, that is social reform or social welfare alone.
Correct, my lord.
So general law cannot make an inroad into it.
No.
This is what you are trying
Exactly.
to say.
So, my lord,
So from there, my next clarification I seek from you is, what is social reform and social welfare? Will the state be understood to be within its limits if it says that it is enforcing constitutional duties in enforcing a law or in making a law under the ambit of social reform? Because the state has some constitutional duties envisaged under the directive principles of state policy. It has a constitutional duty to enforce fundamental duties of its citizens. So will these qualify social reform legislations?
my lord, let us take a case of, say, superstitions. Or let us take a case of completely practices which are abhorrent to morality, but which have been conducted in a certain place. My lord, the legislature can intervene. It can intervene on the grounds of social welfare and reform. So it is not that social welfare and reform, my lord, is very limited. It can be, my lord, actuated by a proper purpose. But however, what I am submitting is the extent of invasion.
I just wanted a clarification. With the word is social
Yes.
and directive principles are constitutional visions.
Yes.
So will the constitutional vision of the state be a part of social reform legislation?
My lord, this is again a fairly profound question. My lord, if your lordships look at the preamble, in the preamble there is both the coexistence of justice, political, social, economic. So, my lord, I am not for a moment downplaying the importance of that question. It's a very valid question because it's, my lord, you have to secure the citizens.
Why I am asking
Yes,
this
yes.
question is because we are delving on the question of constitutional morality vis-a-vis public morality.
Yes.
Now, if we are trying to eviscerate the two, differentiate them, then when it comes to legislative competence of making inroads, should we again make compartments between social reform and constitutional reforms through enforcing visions as envisaged under Part 4 or fundamental duties?
My lord, in one of your lordship's previous interactions, my lord, in these proceedings, your lordship said that constitutional morality could be the conscience of one person, but someone else may have a different standard of morality to judge it. But, my lord, as far as constitutional ideology and assurances are concerned, it is something which is relevant for the state. But, my lord, this freedom, if it has to be preserved as a part of the basic fundamental freedoms which are integral to the basic structure, my lord, this freedom of religion and conscience is inherent. It is a very important freedom. Then I'm afraid, my lord, we have to read the part of legislation very strictly. And it must be able to establish a direct nexus between the need for that reform and the objective sought to be achieved by the legislation to accomplish that reform. Otherwise, my lord, 25(2)(b will be completely an overarching, shall we say, it will be a silent inroad into religion.
Yes. For example, suppose the Kerala rules, Act and the rules, for example, had said, in the name of social reform, the entry of women between the age of 10 and 50 to the temple is permitted. Is it an invasion? Or it could be said that it is not an essential practice and therefore upheld. What's the extent of invasion then?
Well, even in that case, your lordships would have to be satisfied and would need to undertake an inquiry to see whether the exclusion as a part of ancient tradition or custom or usage was one which did not fundamentally take away the rights of devotees to go to the temple. That's not the test. That is, in other words, if it is a limited category and it is based upon a rational, and it is also a custom and a usage, and it belongs not to a denomination, because the word denomination I'm interpreting widely. It is in the context of a faith-based denomination, because it's much easier, otherwise we will not be able to prove multiple communities, and it will be completely, so it's better to make it sound and principled. And I submit with respect, in such a case, if the usage is present, custom is present, it is entitled to respect the Lord ipso facto as a part of that tradition. Customs and usages cannot be thrown away. We will take simple customs before you enter.
The rule has to be struck down.
In that case, it would have to be struck down.
So it need not be on the basis of essential religious practice. Merely because of an invasion into a religious practice, it can be struck down.
It can be.
Because it is only a cloak
it
or
can
a
be.
color of social.
It can be. That's why I'm saying,
yes.
Please treat even, there is an element of automatic strict scrutiny when you come to the words and clause B. Because, you are passing a law to invade religious freedoms. Therefore, it must be a law which passes tests in all senses, it is with the act, it is for the true purpose for which it was intended.
Conversely, if such a ban or whatever it is questioned in a court of law, can it be that ban is struck down on the basis that it is not an essential religious practice?
It can be. It can happen. That is why, please don't throw away the idea. My submission is, please do not jettison this concept of essential religious practice. Please don't, because I'll tell you how useful it is. When Justice Rajendra Gatka in the Dargah committee said, and he was also a very progressive judge, but he was also one who was profoundly learned. He said, the crucial words are, don't allow anything, he used the word superstitious. It's suppose he had not used the word superstitious and said, don't allow anything extraneous to come into religious faith. It's completely unobjectionable. Because when a religious right is asserted, the court will take care to see that it is not a valuable religious right which is asserted. It has to be discovered. And therefore, Justice Rajendra Gatka said, when we have anything which is extraneous, he was so careful. The later words have to be read. He said, if suppose such a claim is made under Article 26B, then that claim will have to be very carefully scrutinized. I think there's no objection which one can take to that sentence.
Now, how do you define this the social welfare or social reform? The question is only with respect to this. 25(1)(a) says it's subject to public order, morality, health, and subject to the other parts of this part. If you juxtapose that to religious denomination, which as well said, they are nothing but a collection of beliefs. Even what is applicable to a person or group of persons is applicable to the religious denomination. So that's the reason why you also said, what is the as my brother Bakshi also said, and the state can be said that state can restrict the right subject to other provision of Part 3 alone, because 25(1) itself is says subject to two factors. One is public law morality, the other is subject to the other part. So give effect to the mandate of other provision of Part 3, from equality, Article 3 and 91G, can correctly said that the power of the state to pass a law is confined to ensure the due compliance of Part 3, other provision of Part 3 alone, because anything else is not restricted under 25 one year. Is it the proper way to look at it?
No, I've understood, Manoj. Let me straight. I'm very grateful. Manoj, my submission, Manoj, I like to be clear because my purpose is to assist you and to help to draw, Manoj, not necessarily bright boundaries, but there has to be clarity and consistency. Manoj, my view is that Part 3 is not available as a ground for legislation under 25(2)(b). And nor is it available under 25(2)(a). 25(2)(a) and 25(2)(b) occupy territories which may have some, shall we say, idealistic overlap, but the legislation cannot be done with reference to Part 3 because, Manoj, what happens in 25(2) is it lifts both. It enables a legislation, but it also removes the subjection to Part 3.
All right. Now, religious practice directly comes in the way of the other provision of Part 3. What will the state do?
It depends upon a case to case. Let me give your lordships a small example.
Under which provision, the provision of law, under which article the state can assume power there?
Lord, that will, if I may say so, Lord, if your lordships don't use the word Part 3, but if it is social reform proprio vigor.
That is obviously prohibited under 25(1)(a).
Yes.
It's subject to that one.
Yes, yes.
So it is so apparent, state is of the view
Yes.
that either it's public order morality or other provision of Part 3
Yes.
is violated by the religious practice. It is so apparent. Can it pass a law or not? If you pass a law, under which provision will come?
Lord, if suppose, let us say, I'll give your lordships a clear answer. Lord, for the purpose of a law under 25(2), Lord, if a law has to be passed with reference to the opening part of 25, or shall we say, opening part of 26, you already have 3 grounds which are available. That is, Lord, the grounds which are public order, morality, and health. There are 3 available grounds. Now, what does actually 25(2) do? In fact, it does is, your lordships are looking at subject to the provisions, other provisions of this part. Subject to the other provisions of this part, my lord, is in the context of protection and equal rights of religion which are granted to others. It is in that context I'm interpreting it. But I'm saying anything, my lord, which comes within, shall I say, the reasonable ken of social reform, my lord, that is social welfare and reform, will pass under 25(2)(b), but it must be established that it is, my lord, an authentic social welfare reform. So I'm saying, so my lord, it might be that a violation of a fundamental right, now I'm going further, violation of a fundamental right may acquire, shall we say, the appellations and attributions of a social evil which needs to be addressed under 25(2)(b, then not the legislature necessarily has that power. So I'm therefore reading that the power is there as long as you can demonstrate by means of objective assistance that this is a social evil, this is a social welfare, this progressively takes it forward. Well, this would be a very harmonious way of reading it, because otherwise 26, as I said, will get unnecessarily impaired.
Because it's better for us to define it. Otherwise, we are telling you this, we don't want to give the impression of giving too much of power to the state.
I understand.
If we restrain, if we draw the contours somewhere,
Yes.
like you are also example, you quoted what I have said earlier, Section 6 of the Intersection Act.
Yes.
If you want to bring it under 25(2)(b),
Yes.
it is not only you can't bring it as public welfare and then say the public reform, but necessarily you have to go back. What is the extent? To that you have to go under Article 14, 15 and other provisions also. Because it is subject to that. Because if they come under this, because absolutely it shuts the door for the religious practitioner. Because it's subject to that one. Your right is subject to that under the Constitution.
May I just explain the point? Like Section 6, it's an excellent point and it's a very good example. Section 6 belongs to the realm of personal law, as your lordships know. Your lordships know the progression in relation to the right of a widow to hold property, first, my lord, under the 1937 Act, and even under the 56 Act, my lord, it was the Justice Syed Fazal Ali's judgment in Tulasamma, that is, when he said 14.2 is absolute. It is only then, my lord, the law became firm that they had absolute estate and they could alienate properties. Till that time, my lord, it was not possible. Now, this, my lord, is actually an amendment. But as your lordships rightly are aware, that there can be even discriminations within the realm of personal law. The removal of that discrimination can still be a social welfare reform, which is directly falls within the province of 25(2)(b). So, my lord, for the purpose of removal of discrimination, you don't necessarily have to go back and hearken to 14, although it is a salutary. But, my lord, you can remove it as a part of social welfare.
For example,
Yes.
sir, religious denomination believes that a lady who becomes a widow has to commit sati, and therefore sati must be abolished in the context of 25(2)(b). It cannot be considered to be an invasion of a religious practice.
Certainly not.
We are giving these extreme examples. So social reform will prevail there.
Yes, certainly. And, my lord, it's not only the making of a law, as your lordship said, it is also, my lord, the conscience with which that law is implemented over a period of time. My lord, even though we have had laws which were social reform laws, as a matter of accurate, my lord, if one had to do proper sociological studies, it has taken a lot of time for many of them to have been translated as complete realities. So there is a gap, my lord, even between effectuation of a law and the time by which, my lord, society adequately responds to the law and imbibes the law as a value. So, therefore, my lord, I would honestly say that under 25(2)(b), social welfare and reform, my lord, are capable of a wide expression, but they must be, my lord, honestly falling as social welfare and reform, and they must not also, my lord, completely eviscerate the right of the denomination under 26. That is the point.
Yeah, harmony, that's what in Venkatramana Devaru,
Yes.
ultimately it is stated. The proportionality.
In fact,
What is invading what?
I
in
think
fact
we
that,
can probably, the issue I think stands quite well between. Part 3 is an embargo on 25(1), the individual devotee's right, that when you exercise that right on 25(1), you have to respect the Part 3 also. So far as social welfare or social reforms are concerned, it's a very wide term. State is not a stranger, state is not an alien. State represents the will of the people. And if the people want certain social evils to be reformed, probably that power can be exercised. But it's very difficult for us to lay down any future guidance. It will always depend upon a case to case whether the reform falls within the ambit of 25(2)(b) or it amounts to exceeding the power under the name of reform, introducing something which amounts to infringement of a religious practice protected under 25(1).
and my lord, to be fair to the learned Solicitor General, who do not have the benefit of so many other submissions, he seems to take that position. His position is that there is a separation between religion and the state. Second, there should be minimal state control or incursion when it comes to 26(b). Third, he, my lord, went up to a point, but elaborated it, that every denomination means, my lord, it belongs to every faith. Section thereof will deal with all these subsects. And lastly, my lord, on this question of 25(2)(b), that power, my lord, must be available with the state, even though denominational freedom is being given and the right to religious practice is being totally accepted and preserved. So, my lord, with this, I'll be very quick and brief. My lord, if I may just give me my lord, I have given an additional submission for your lordship's consideration. But on this concept of religion, I wanted to show a few passages, my lord, from the original submission. Malad, this is volume 1.2 in the soft copy.
596.
Malad, it starts at 595. And if I may take your lordship straight away to three paragraphs, 19, 20, and 21. That's at page 602.
Volume?
19, 20, volume 1.2, my lord, page 602.
Para 19?
Para 19, my lord. It is submitted that the etymology of the word religion is from the Latin word religare, and the concept itself is difficult to define in such a way as to comprehend. So sorry. Page 602, my lord. Well, the running and PDF are the same, so fortunately. 602, para 19. Incidentally, my lord, as a digression, the reason why Justice Mukherjee, one sentence that it's not possible to give a rigid description for the word religion is, my lord, largely because he followed also, my lord, the section of philosophy, Bertrand Russell's theory of specifications. So unless you have a completely exhaustive enumeration, you don't say, you rigidly define a particular term. So, my lord, that is why those words come in the beginning of the passage. Then, the Latin word religare and the concept. Sir Edward Bernard Taylor defines it simply and briefly as being a belief in spiritual beings. According to Goblet Alveolar, religion is a certain method by which man realizes his relation to the superhuman and mysterious powers upon whom he regards himself as dependent. A more comprehensive definition is that given by Yoreve. Religion is essentially a principle of life, the feeling of a living relation between the human individual and the powers or power of which the universe is the manifestation. What characterizes each religion is its way of looking upon this relation and its method of applying it. Perhaps one of the better indicative definitions is that of Fraser. By religion, I understand a propitiation or conciliation of powers superior to man, which are believed to direct and control the course of nature and of human life. In more contemporary terms, Professor Thomas Tweed defines religion as religions are confluences of organic, cultural flows that intensify joy and confront suffering by drawing on human and supra-human forces to make homes and cross boundaries. Well, this, I submit, gives you at least a wide array of thought of what actually is religion. But, my lord, it is clear that the religious faith, in all these cases, my lord, everybody has taken off from saying this is a Hindu faith. But, my lord, unless you understand what facet of the Hindu faith is that particular temple or that particular agama is dealing with, the picture looks incomplete. It looks that we are only looking at rituals in that case. It is really the philosophy, my lord, which is equally important. And as I said, my lord, we have 6 schools of philosophy, but you have any number, shall we say, my lord, of Vedanta, you've got Dvaita, you've got Vishishta Dvaita, and my lord, even in these, if I may say so with respect, the distinctions are more often than not of form, not always of substance. If one has read through, my lord, this particular subject. For instance, my lord, one of the greatest misconceptions is that Adi Shankara was a monist and he believed in Advaita Vedanta. My lord, this is a straightforward statement which your lordships will hear most people say. The reality, my lord, is slightly different. If anybody reads his Bhashyas, he says Dvaita does exist. And he says that there has to be sometimes attribution to form. Not ideal is the form of Saguna Brahman. That is the concept. So you do need Dvaita, but Advaita is not the end. There is still one more when only the absolute remains. Malad, that is actually the correct interpretation of Shankara. In fact, Malad, the number of stotras which he has composed is a legion. So therefore he is not Malad only an Advaitan as is normally understood. Malad, in Vishishta Advaita, that is, God alone exists. Although there is a duality, but it is he who has all the attributes. You don't actually claim any partiality or a part of that. That is Malad Vishishta Dvaita. Dvaita Malad, which is mostly in many Vaishnava and other Sampradayas, is where you have Malad a dual relationship between God and yourself, the devotee. In Malad Shiva Siddhanta, that is actually Malad extremely, it has got so many dimensions, particularly in the context of realizing Shiva within you. Malad, it is, if I may say so, I beg your lordship. Self-realization. That's right, Malad. That is why there is a school of thought that it is Shiva alone who is the ultimate silence and who is the creator of time. Now, I'm explaining this because each philosophy is different. Take the case, Malad, of Sri Ramakrishna. I'm giving another example. Malad, in fact, the Gold Path, Malad, had a beautiful collection, history of Indian culture. And it's Malad, one of the most fascinating collections.
One of the best libraries on spiritual.
Yes, certainly, Malad, without a manner of doubt. And Malad, there, in that philosophy, what the propounder of that faith says is, you realize God by whatever ways and means you can. There are any number of it. Now, Malad, this is one. Now, take the case, let me just give your lordships, Malad, a religion like Zoroastrianism. I'm hearing for some of these trustees. I'm just giving your lordship the idea what I meant by those 4 factors. The 4 factors are, they also, the Avestan language was close to a Vedic Sanskrit. They're very ancient, not extremely ancient. And it is also Aupurusheya, that is by way of revelation. That is belonged to Zarathustra. Yes, he was revealed. And Malad, that is the basis of that religion. It is monotheistic. And Malad, they worship fire and they have a set of principles. That is Malad, one kind of faith. I'm giving you lordships different only for the purpose of understanding that there are some overlaps too, as one will see this religious freedom. Take a third case, Malad. Take the case of Buddha. Malad, whether it is Theravada, Mahayana, there were substantial differences. But the fundamental philosophy was based upon the 4-fold principle that you have to extricate yourself from the human misery, which is only possible when you remove all the senses of want and craving which lie in your mind through the 8-fold path, and ultimately you then Malad, get moksha, or you get nirvana. That is Malad, that philosophy. Now, Malad, the Jain philosophy had ahimsa, it had Malad aparigraha, that is, you should not possess. Malad, they have these tenets of purification, and by purification, they believe in moksha. They also believe in the theory of liberation. Malad, take the case, for instance, Malad, of Christianity. Christianity, Malad, has actually 2 parts. One is the Old Testament, and the second is the New Testament. The Old Testament, Malad, is actually the Jewish, some books of the Jewish Bible are consolidated together. The New Testament, Malad, consists of the Gospels, which are the direct experiences. That, Malad, is again a faith. It is a dualistic faith where you believe in the personhood of Jesus Christ as representing the Heavenly Father, and that He went on the cross for your redemption. Malad, that's just, I'm giving you an outline. And each one of these religions, Malad, have a philosophy, they have a scripture, they have not only that, Malad, they have a practice, and they also have ways of communicating with each other. So, Malad, the proponent, if I may say so, exists in all faiths, And therefore, Malad, the point which Justice Amanullah yesterday asked, that if suppose I want to go and meet my Creator, why should anyone come in between me and the Creator? He asked the question, but I understand how that question arises. My Lord, in Hinduism too, there is meant to be no gap between you and your Maker, as a matter of fact. But when you come to the 26th field, and if you enter a temple, then that temple is actually designed in a way that the Holy of the Holies, as Justice Mukherjee says, must be so sacred and must be kept with such sanctity that you are not allowed to enter there. That is not a restriction on worship. You can stand from your vantage point and offer worship. So, however, my Lord, the concept of personal belief, that is, you are leading someone in prayer and it is only between you and the Almighty, my Lord, that is sacred space. That sacred space, my Lord, is not attempted to be invaded. So if suppose, my Lord, somebody went on a purely contemplative tradition in Hinduism, it would only be between him and his Maker. There would be no one else. So, my Lord, there are different traditions. This tradition of worship in a temple is one of the traditions, and my Lord, because this tradition has come up repeatedly in various judgments, it looks slightly daunting, but it is, my Lord, really one of the traditions. It is not the sole tradition of the faith. So, my Lord, the concept of karuna, again, my Lord, is actually common to all faiths. The concept of compassion is common to all faiths. So, my Lord, when we talk therefore of religious freedom, the constitution makers, my Lord, were aware not only of the multiple faiths, they also knew, my Lord, what exactly was this faith about and how necessary it was to have that faith. Because after all, as your Lordship saw, to face the trials and tribulations of life, you do need skills, but you need faith. And that is why this religious freedom is so special. So, my Lord, having said this, may I take your Lordship straight away?
Mr. Subramaniam, I'm thankful for clarifying that. One thing now the opponent said, if I understood you correctly, that there is a connection, direct connection between God and you in the Hindu faith. But then when a temple, which is an institution set up by a denomination, if you want to go to a particular temple, then the beliefs of that denomination have to be adhered to. So it is not a restriction on your connection with that deity.
That's right.
But then that will have to be respected.
That's right. That's right.
Because that has been set up by that denomination with a particular belief and a set of principles that will come under the protection under protection.
And that is why, my Lord, now may I take your Lordships to Vijay Mukherjee's lectures, some important portions, because your Lordships will find everything falls in place. All that which I have said falls in place, and your Lordships will find that there is contiguity. And, my Lord, this is necessary to understand. May I invite your Lordship's attention to the volume number 4.6, my Lord. Please come to printed page 796. Page 4, 796. I'm taking your Lordship straight to the volume 4.6. Does your Lordship have, my Lord, the third paragraph on that page? It is, my Lord, 796.
Which is the page?
796, my Lord. But as His Lordship is getting the page, my Lord, there is a very inspiring live sketch on Justice Mukherjee, the AIR 1955 journal, It is, my lord, a very inspiring biographical sketch of his life. Well, there are only two people who got this degree called Saraswati. One was Sir Ashutosh Mukherjee, the other was Vijay Kumar Mukherjee. And my lord, he was a great worshipper of Shiva.
Yes.
But you're all, my lord, carrying that heritage and inheritance, all of your lordships. My lord, please see the third panel on that page. Sorry, somewhere. I'm just waiting for it. It's on the screen, my lord, but he has independence. Yes, Hindu religious and charitable acts have been from the earliest time classified under two heads, namely Ishtha and Bhukta. The two words are often conjointly and they are as old as the Rig Veda. The compound word Ishta Bhukta has been retained in the writings of all Brahminical sages and commentators down to modern days. And although the connotation of these two expressions was extended to some extent in course of time, the fundamental ideas involved in them remained practically the same. By Ishta is meant Vedic sacrifices and the rites and gifts in connection with the same. Bhukta, on the other hand, means and signifies other pious and charitable acts which are unconnected with any Shrauta or Vedic sacrifice. And my lord, Prannath Saraswati, my learned friend Dr. Dhawan, had placed that page. My lord, this is that same gentleman. He was a predecessor, my lord, of Justice Mukherjee in those lectures. Now, my lord, the next portion I wanted to show to your lordships is at page 800. Now, my lord, after dealing with the subject about Vedic times and absence of idols at that time, my lord, this is because he's tracing when exactly was this established as a tradition, that is, my lord, idol installation and so on. Please see, kindly come to page, my lord, 801, the second panel. The strongest argument in support of this view is furnished by the form of worship prevalent in the Vedic age. It was quite different from the modern form of adoration of gods which is described in the Puranas or Agamas. So, my lord, this was a much later development. The worship detailed in the hymns of Rig Veda consisted of offerings, prayers and praises in honors of the gods. The offerings were mainly of clarified butter which were poured on the sacred fire and so on. My lord, he gives a description. And then thereafter, please come to over the page. Second panel. There is also no mention of monastic institutions in the Vedic literature. According to the Vedic Grihya Sutras, which regulated the life of man, there were the institutions of 4 ashramas prescribed for all persons belonging to the twice-born caste. Then thereafter, your lordships will find, well, just out of interest, I'm not trying to persuade your lordships in any way, but he refers to the concept of an aistic brahmachari. If you look at that page a little lower, he explains it. Well, that's an ascetic. Then please see over the page, after this, well, then he refers to the establishment of the temples, and then there are a lot of essentials in respect of a temple. He deals with Debata Shivayanship also in lecture 5. and he deals with religious institutions or mutts in lectures 8 and 9. And this is how, my lord, he also then deals with this distinction between private and public trust, my lord, in the light of your lordship's question 1202.
Page 1202.
Yes.
The word used is of a public character.
Yes.
So public character means straight away public and private, or there can be a private trust with a public character also.
Yes, yes, it can be. That is exactly why I'm reading this passage. Because in the context of denomination, your lordships asked me a very searching question. And please see this. Section 92 applies only when the religious or charitable trust is for a public purpose. As Justice Mitter observed in Novi Shirazi versus Province of Bengal, the essential distinction between a public and a private trust is that in the former, the beneficiaries are definite and ascertained individuals, or who within a definite time can be definitely ascertained. But in the latter, the beneficial interest must be vested in an uncertain and fluctuating body of persons, either the public at large or some considerable portion of it answering a particular description. The fact that the uncertain and fluctuating body of persons is a section of the public following a particular religious faith, or is only a sect of persons of a certain religious persuasion, would not make any difference in the matter and would not make the trust a private trust. So, my lord, this is the test. So really, the correct answer to my Lord Justice Sundaresh's question is, if it is for a section of the public, and the public, other members of the public can also visit and pay obeisance at the temple, it is then, my lord, it fulfills the criteria subject to organization, it fulfills the criteria of denomination under Article 26 and also falls within Article 25(2)(b), namely, my lord, a Hindu public institution for religious worship. I'll take that note, but I'm going to re-deal with the questions. My lord, I have laid out my submissions in that note. I want your lordships just to make 2 notes because I don't want to take up, my lord, more time than is necessary. In my note, my lord, there is a section which your lordships will notice, if I may just give it. In my note, my lord, I have referred to the preface of Rabindranath Tagore, my lord, in the first volume in the History of Culture. Your lordships will find that at page 58, my lord. 59 is the actual 61. This is, my lord, this is the preface of Rabindranath Tagore to the first volume. This was published, my lord, in 1938.
This is volume 1.
Yes, my lord, the additional volume, which your lordships have. There's an additional volume, the aid memoir. Of course, it hardly looks like the size of an aid memoir. It's running page 61.
Page, Mr. Gopal?
Yes, this is this one, my lord.
This page number?
61.
Yes, this is good.
So, my lord, this is Tagore's preface. And, my lord, it is a very beautiful preface because he has quoted, my lord, one of the verses from Shvetashva Parita Upanishad, where, my lord, the importance is the principle of equalization, which is stressed in all these Upanishads. Your lordship has 61, my lord justice. My lord, this is the new submission. Can you check whether his lordship has? And Milord, this is what Tagore writes. I love India not because I cultivate the idolatry of geography, not because I've had the chance to be born in her soil, but because she had saved through tumultuous ages the living words that have issued from the illuminated consciousness of her great sons, Satyam, Jnanam, Anantam, Brahma. And my Lord, Brahma is true, Brahma is wisdom, Brahma is infinite. Shantam, Shivam, Advaitam. Peace is in Brahma, goodness is in Brahma, and the unity of all beings. The householder shall have his life established in Brahma, shall pursue the deeper truth of all things, and in all activities of life dedicate his works to the eternal being. Thus we have come to know that what India truly seeks is not a peace which is in negation or in some mechanical adjustment, but that which is in Shivam, in goodness, which is in Advaitam, in the truth of perfect union. India does not enjoin her children to cease from karma, but to perform their karma in the presence of the eternal, with the pure knowledge of the spiritual meaning of existence, that this is the true prayer of Mother India. He who is one, who is above all color distinctions, who dispenses the inherent needs of men of all colors, who comprehends all things from their beginning to the end, let him unite us to one another with wisdom, which is the wisdom of goodness. Now, my Lord, this is the end of a Veda, because an Upanishad is usually, my Lord, the last portion of a Veda. But even, my Lord, in the Puranic literature, I'm just giving an example, my Lord, the concept has been to look at all human beings. In all human beings, the concept is always you look at all human beings. For instance, my Lord, in one of the 700 shlokas in the Durga Saptashati, there is one which says, Ya Devi Sarva Bhuteshu. The word Sarva Bhuteshu is necessarily in all human beings. Nyaya Rupena Samstita. That is, that element of justice is celebrated by, well, this is important because there has been a tradition of acknowledging equality as fundamental even in religious faith. It is not that equality is only secular equality, which has happened as a result of constitutions and so on. But it is
Article 25(1).
Yes.
All persons are equally entitled to freedom of conscience. No conscience is superior to any other conscience.
Completely, my Lord. And this itself, this all persons equally entitled. Now, my Lord, let me deal with that word conscience, because that was one question which my Lord Justice Bhakti asked, and it was also in the context, this is which volume? My Lord, if your Lordships would take up volume 1 of my additional materials, PDF page 3. My Lord, PDF page 3. It is printed page 2, my Lord, I'm sorry. Printed page 2, PDF 3.
What's the volume?
Additional volume number, additional research material. Your Lordships notice the word conscience. Page 2, my Lord. Look, this is the bigger Oxford Dictionary, the 17-volume dictionary, which I'm referring to here. Please see conscience. And if your Lordships will see on the right-hand side, knowledge within oneself, consciousness, conscience, know along with another, to be privy with another to a matter.
Where is it?
Left-hand column, my lord. Page, my lord, printed page 2, PDF 3. Column 1.
Knowledge within oneself.
Yes. Your lordship notices that, my lord? Conscience. Your lordship has found that. Now please go to item 1. Inward knowledge, consciousness, inmost thought, mind. Then 1A, inward knowledge of consciousness, internal conviction. Then, my lord, if your lordships will go to the right-hand column, my lord, in the middle column, I'm sorry, column 2. In column 2, item 4, the internal acknowledgement or recognition of the moral quality of one's motives and actions, the sense of right and wrong as regards things for which one is responsible, the faculty or principle which pronounces upon the moral quality of one's actions or motives, approving the right and condemning the wrong. And then on the right-hand column, if your lordships will find number, well, just below number 9. My lord, please see 6. I'm sorry, 6, my lord. Practice of a conformity to what is right, equity, regard to the dictates of conscience. Now, my lord, this finds an independent place, as your lordships will notice in this. I have, my lord, also given excerpts of in relation to the etymology of religion and so on and so forth. But, my lord, let me take your lordship straight to page 92. This is running 91, PDF page 92. This is, my lord, please see page 91. This is from the Encyclopedia of Religion and Ethics, Conscience. Does your lordship notice that, my lord? Conscience operates, page, my lord, 91, printed page 91. Conscience operates when the individual passes an intellectual judgment on definite acts, accomplished or purposed of his own, and decides whether these acts are right or wrong. Such judgments, being self-regarding, are always accompanied by self-satisfaction or dissatisfaction, according as the individual feels he has fulfilled or fallen short of the moral law. Well, there is a description of this faculty of conscience. Well, the reason why this is being put separately is it may travel with religion, but it may travel even independent. So it is wider. It has got its own place, my lord, shall we say. The ability to discern, that, my lord, is a moral judgment. That moral judgment, my lord, sometimes may be influenced by religious factors, but other times, my lord, can be purely a rational decision based upon reason and, my lord, in a sense of equity. So therefore, my lord, I submit the word conscience also has a standalone place in 25.1.
It don't be related to any religion.
Exactly.
The latter part of 25.1 relates to a religion.
That is why, my lord,
where it coincides.
There it coincides, and that is why, my lord, this equality of all conscience, freedom for all human beings to profess their conscience and act according to their conscience, it's, my lord, an innate freedom. And that freedom has been so solicitously preserved. The reason why, my lord, the general application of the principles by the majority in Sabarimala. Well, there are 2 points. One is about constitutional morality. The other is just implying all Part 3 articles in Article 26B. That is not correct. Because Article 26, as your lordships have seen, does not have the same provisions as in 25.1. And the omission of that, my lord, cannot be done on the basis of implied reading. cannot be undertaken, my lord, on the basis of an implied premise that because the Constitution exhorts liberty, equality and dignity, that it follows a fortiori that other articles of fundamental rights cannot be completely obviated and must influence the construction of 26B. That, my lord, is the legal error. And I submit the reason is these rights belong to an area which Justice Bagchi perceptively remarked in the opening day. It is a non-secular area. It is an area between yourself and others and yourself and your maker and your personal space. Well, this is a different space. In this space, the articles may have a bearing to the extent that if you're going to act in accordance with equity, one must assume you would act equitably towards other human beings. But that, my lord, is not the test. Whether juridically can it be said that the articles in part 3 flow into 26B silently without there being an express incorporation? And this is, my lord, the question. And this conclusion, my lord, has been derived at from, my lord, a slightly broad-based preambular understanding, quickly leading to the fundamental rights, and also referring to 17. 17, my lord, is not irrelevant, but that is already taken care of by 25(2)B. That is the point. 17 also has been taken care of by 25(2)B. Therefore, my lord, this test is not the correct test. That is why I said, my lord, I'm sitting on the side of the review petitioners, because according to me, the exposition of law by the majority on this is not correct. My lord, on the question of constitutional morality, my lord, there are 2 points of view. Yes. Well, the previous point is I'm saying that as far as 26B is concerned, it is not subject, my lord, to part 3 rights, which is the position in 25(1). And what Justice Chandrachud and, my lord, Chief Justice Mishra, the majority opinion, is that they have infused those articles and those guarantees for the purpose of interpreting 26B. This is one. The second error, my lord, is the error which the learned Solicitor General pointed out in 25(1). They read equally entitled to mean that it also meant gender equality, but it's to all persons. So that is also, if I may say so, not necessarily a conformist reading as far as 25(1). And I submit, my lord, because of these 2 errors, I submit that this position is not correct. The majority judgment is not correct on law. But I now deal with the point relating to constitutional morality. Sorry.
See, with regard to, you said this, in the context of conscience, there it becomes non-justiciable.
Yes.
It becomes non-justiciable. Therefore, the court cannot go into the rationality of that conscience or the quality of that conscience.
My lord, may I've understood.
Therefore, there are certain aspects of religion which the court cannot sit in judgment of.
My lord, may I just go a little slowly?
There where religion and conscience are interlapping or overlapping.
My lord, let me take the case of first conscience proprio by itself, then I'll deal with conscience and religion. My lord, conscience, your lordships are right, the extent of rationality, the extent of what is being processed by the conscience of a person is not open to judicial review. But, I now say but, and I say it very humbly, that if it manifests in an act which impacts rights of others, that is, it assumes the form of an action, a physical action, then in that case, my lord, a court may look at it. But there, my lord, it is no justification to say that I was propelled by my conscience to do something. You will have to justify it with reference to legal principles or legal defenses which are available. Let me come to the more difficult question, which is between conscience and religion. My lord, here, if I may say so with respect, there can be overlapping. This overlapping can be, my lord, again, it really belongs to the realm of faith. That is why, my lord, I have kept this word faith completely away, because that is completely the subjective experience of the believer or the worshipper. In that area also, my lord, you will not be able to interfere. But what you can effectively account for is the existence of a faith, because it's necessary for establishing the right to know the tenets of the faith, so that you can uphold the practice or uphold, my lord, the rights which are being claimed, and also so that you can see whether any invasion by the legislature, either under 25(2)(a) or 25(2)(b), my lord, is disproportionate, excessive, and actually obfuscates the freedom itself. To that extent, my lord, you certainly can look into it. Now, my lord, one last comment before I answer, my lord, one more question. My lord, in these written submissions, I have actually listed, my lord, all the dates, much like what Mr. Sai Deepak did yesterday. But your lordships will notice the word every denomination occurs without faith. And it is in the context of religion, every denomination must necessarily mean, my lord, religious denomination. So, my lord, the big religious denomination subsumes within it all sections thereof. My lord, I have had a look at the various questions. My lord, I therefore submit that the definition of religion as propounded by Justice Mukherjee, although he said I can't give a rigid definition, but later, my lord, he says it's a system of beliefs and systems of belief connected, my lord, in an organic whole. My lord, that definition should be accepted. I have said so, my lord, in my written note of submissions. Now, my lord, I'm open to any.
Mr. Subramaniam, just following what you said from sister, my question I've answered there. The 25 just above that is right to freedom of religion. But then 25 uses the word freedom of conscience and free profession, practice and propagation of religion. So, is it not an indication that conscience itself can be equated as a religion itself? Pure conscience, devoid of any formal religious association with it, by standalone, itself can be equated, because just above that is right to freedom of religion. But then the word is conscience and religion is with regard to free profession, practice and propagation of it. Can it not be just a standalone? My pure conscience can also be equated with that of religion?
My lord, there are two answers to it. In terms of, if I was a moral philosopher, I might say that it could stand on as high a footing as religion. But, my lord, that is not the lens which one must employ for judging this particular expression. I would say, my lord.
Why I'm saying this? Because
yes, certainly.
Right.
It is.
It's not collective.
Yes.
Standalone, I can also have my own. My conscience and the constitution equates it with the religion.
My lord, there is a distinction between conscience and religion. Religion is in the context of a set of beliefs enjoyed over a period of time, established, my lord, doctrinally. That might be external to the person. So religion in that sense is, they could be overlapping, as I said, my lord, in terms of the acts of conscience. But in terms of calling it as religion, my lord, if your lordships were to use the word religion as an adjective, that is as a word, that it is as important as religion, I don't think, my lord, I would have anything to say. Yes, it is as important as religion. Because, my lord, there can be a host of people who are agnostic, atheistic, and they all, my lord, may have the soundest and most robust conscience. It's perfectly possible. So, I would say that conscience does have a unique place in the setting of Article 25. Your lordships can say it is perhaps as exalted as religion, but the meaning, my lord, may not be identical. If there's any other questions, I'll be very happy to.
Any submission on
I have given, my lord, my
morality.
my lord, on constitutional morality, my lord, I just, if I may say so, it just slipped my mind. My lord, constitutional morality does exist, my lord, as a concept. It is not completely an outrageous, or it is not a concept which needs to be discarded from consideration. It has value. And the concept is born out of, my lord, shall we say, not only governance, your leadership is right, it's also out of governance, but more importantly, my lord, out of the spirit of the Constitution. In other words, something called, my lord, a golden thread, which keeps the Constitution organic, whole, and also lends to the Constitution the ability to be a living tree. Well, the reason why our Constitution is different from other constitutions in the world is this is a living tree. This is meant to actually talk to us in the present. It is meant to be a living document. And that is why, my lord, we derive strength from the Constitution. So, my lord, constitutional morality, viewed in terms of the spirit of the Constitution, it is a reasonable expression. It may help you to accentuate certain aspects of, my lord, a declaration. But is constitutional morality a doctrine of independent constitutional sanctity that it can be invoked for the purpose of avoiding or annulling or declaring rules or legislation? I'm afraid no, my lord. You have to look to the specific provisions of the Constitution, and there may be more than one of them. The fact that there are more than one of them does not make it, again, constitutional morality. But the phrase itself, my lord, should not be, if I may say so, it should not be debunked. It is a phrase which you should retain, but it is not a doctrine of negation as far as that is concerned. Then what is the meaning of the word morality? Again, my lord, I have plenty of extracts. I have referred to them, my lord, in my submission. My lord, for the present, I would say that although Dr. Dhawan was kind enough to say it is a slightly restrictive conclusion, is that just as Nariman said something morally abhorrent to civilized ideas in a society, that I think, my lord, is reasonably narrow, but it also accords with the ideas of morality in the other parts, that is in the subsidiary in 19, 2, 3, 4, and 5, and 6. So therefore you will have some consistency in reading the word morality. The word morality, my lord, in Article 25 and 26 is not constitutional morality of an overarching sense, but is intended to be a restraint only that much which is necessary to ensure that it can be a trespass on your fundamental rights. So if you read it that way, well, the logic which I applied to 25 to A and B, I am saying the same, even in respect of morality. That what I appealed to your lordships was, please engage a narrow but well-tailored scrutiny of 25 to A and B. Then the same by analogy. Analogy is one of the ways by which you can ratiocinate. So by way of analogy, even in respect of the expression morality, your lordships may give a limited meaning which comports with the subject of the article. So morality, my lord, for speech may be different from morality for religion. It may not be, not always the same. That is why the placement of morality with reference to the nature of the right which is being exercised is also relevant. For instance, my lord, for freedom of association. So, my lord, I submit with respect, we should not think that this is no more than an exalted 19(1)(c) traveling in 25. This is an independent freedom which has been guaranteed under 25. And above all, my lord, the most vital consideration for your lordships to keep in mind is the equality of all religions and an interpretation which conduces to all. And my lord, this will be something which the constitution makers truly wanted to accord in spirit, namely the equality not only to men, to persons, but equality to all religions and to practitioners of all religions. But I'm more than happy to answer any other question.
If I've understood you correctly, you said that constitutional morality cannot be a ground for judicial review. If I've understood you correctly.
It cannot be an exclusive factor, my lord, in judicial review. That is, it cannot annul, shall we say, a statute judicially reviewed.
No, but then how do you...
It is not a limitation. I'm grateful to my friend.
How do you explain that morality is restricted by the word constitutional? whatever judicial review is done by the court basically has to be to harmonize the provisions of the constitution. So if morality looked in the scheme of the overall constitution, how can you say that it should not, why cannot be the ground only for judicial review?
Well,
But
it could be.
ultimately it is not going beyond the constitution. The morality has to be restricted, the test has to be within the constitution.
Well,
The constitution is sacrosanct.
I've understood your Lordship's question. But may I give an example? It is not that Article 14, which are anti-discriminatory, non-arbitrariness provisions, do not embody a moral principle. They themselves embody a moral principle. Bega establishes a moral principle. Likewise, my Lord, 17 is a moral principle. And, my Lord, I submit with respect, therefore, if your Lordships were using these as provisions, they may suggest additionally a dimension of constitutional morality. But when we use the word constitutional morality as some kind of a doctrine without reference to the constitutional provisions, that is when, my Lord, the doctrine becomes, if I may say so, deeply vulnerable. But if you traced it, as you said, to different articles of the Constitution, my Lord, a certain morality can speak. My Lord, when we talk about judicial conscience is upon an application of all these faculties. So therefore,
In other words, what you are saying, you can use this, the concept of constitutional morality, to understand the constitutional provisions. And we can take it.
yes, that is actually, my Lord, my submission.
It cannot be a test or a strike down legislation.
Yes, it cannot be a test which is, my Lord, an independent test, which is therefore a limitation of being exercised in judicial review. My Lord, is there any other question?
Thank you, Mr. Gopal.
We want to know all human beings are bound by conscience, irrespective of the nature and quality of the conscience.
My Lord, in fact, in my additional submissions, your Lordships will find this is the preamble of the 48 Declaration, exact words. What your Lordships uttered is the exact preamble of the 19th Universal Declaration.
That is what makes a Homo sapien different from an animal,
Completely.
which we don't realize.
Thank you, Mr. Gopal. Thank you very much.
Very grateful. So, my Lord, I didn't read this. I'm sure your Lordships would read this, and I just thought I would touch upon the aspects which have arisen as a result. Grateful.
Please, Your Lordship. My Lords, I am appearing for review petitioner. I am for a review petitioner.
We know that.
Let me tell my lords what I intend to do. I'm not going into every one of the issues. Your lordships have heard many learned submissions on the written.
Supposed to wind up today,
Yes.
but we are granting one extra date, so bear with us and we will very quickly close.
My lords, my aim is to do this. Your lordship has various issues. I want to bring it down basically to what is Article 25, what is Article 26, what are the parameters in these. Much has been spoken about religion. My lords, there is a lot to be said about religion as religion. But I'm more concerned about what Articles 25 and 26 say, and in particular, I want to answer certain questions which have been raised by your lordships in the hearing, which is why I'm not going to my huge written submissions. I'm going to a very small 6 propositions.
Better address your principle which you want to.
Absolutely. So, my lords,
Not our question, we keep on asking questions.
my lords, what I'm going to address, my lords, are on these broad principles. It's all in one.
Yes.
6 broad principles.
In which volume your arguments are there?
My lords, my arguments are in volume 1.1,
Better we take this piece.
page 500, 507. My lord, at the time of filing, the petitioner, my lords, was the president of the VHP Kerala, and my lords is currently the general secretary of the Sabrimala Karma Samiti, as also the national chairman of the Sabrimala Ayyappa Seva Samajam. My lord, can I just give your lordships the broad principles on which I want to go, before which I would like to answer your ladyship's one question earlier on what is conscience. My understanding of conscience, pure and simple, is it's a moral compass within which each one lives. If we understand that to be conscience, we look at it as our own moral conscience of what I feel is right and wrong, which someone else may not give him equal importance to. But there are what we have always called absolute rights, absolute wrongs, which are pernicious behavior, which you cannot claim protection of conscience. In that background, can I just take your lordships to these broad principles? First of all, religion, for all the learned discussion on religion, boils down only to this. It is an expression of belief in a superior force. A particular God is a personification of that belief. Why I would like to emphasize this is that, especially I know in the south, probably all over India, a temple is really an abode of a particular deity. It is where a deity in the form we want to worship that deity is. So, for example, if we take Ayyappa, Ayyappa has in various forms. Each temple worships that deity in that form, treating it as the home of the deity. For example, Guruvayur, while it is Krishna the child. The entire religious feeling is towards the deity in that form, and to that extent, please consider my primary submission, my lord. A temple, a religious institution, is really an abode of a deity. Which is where this question of essentiality test I am not able to understand. Why? If it's a religious practice, it is a religious practice, and with freedom of conscience which does not trample on somebody else's toes, I can follow my religious practice. The moment we say essential religious practice, it becomes a question of fact. That question of fact then is left to the courts to decide an ecclesiastical matter, which we say we will not do. It becomes a jury question. Is it essential? Is it not essential? And at the same time, we say the courts will not enter into ecclesiastical matters. So this concept of essentiality is not relevant. What is relevant is the concept of whether it is a form of religious worship. That is all. And whether that form is found either in the Shastras or through long custom or through long usage, or is the manner in which a group of people want to worship the deity. And my lords, we cannot go beyond that. My lord, where I disagree with some of my colleagues is that Article 26, I believe, certainly does not exclude Article 25. The two have to be read in tandem. The word class in Article 15, here again I disagree with some of my colleagues, does not exclude only those contemplated under Article 17, but will apply to castes as in communities, as in class as in caste, communities, others. But it is my submission it will not apply to gender. Because where gender is intended elsewhere in Part 3, gender has been referred to and has not, my lords, been passed in a generic class. The power of the state under Article 25 includes denomination. So according to me, 25, 26 have to be read together. The state certainly has the power under 25, 1A and 1B, qua denominations also. And there, to the extent that it was said that 26 is not subject to 25, I do not agree with that submission. I, on the contrary, say, yes, it will apply. However, my lords, the power of state under Article 25 would include denominations, but only qua class and sections. And it is my submission, although the disjunctive is used as or in Article 25, but only for reasons of social reform and welfare. My Lord the Chief Justice earlier said, which is the idea I subscribe to, that whether considering a particular practice and whether removing that practice is for social reform or not will be a matter to be decided in a particular case. What is absolutely barred by the Constitution, of course, for example, Article 17. But the others, what nature of social reform? And the social reform has to be taken qua the activity, qua the form of worship, qua the deity, and qua the manner of worship of that deity. You cannot take social reform in an abstract sense. You have to say, for the worship of this particular deity, in this particular form, this particular custom abhors the conscience. This particular custom should be done away with. Your ladyship referred to sati. That's a very typical example. Very typical example. Should be done away with. But that will be tested on a case-by-case basis, and there are no absolutes so far as that is concerned. And there can never be absolutes. And so, while it is recognized that for a larger good, for social reform, and here my Lord Justice Bagchi pointed out that social reform could be read in lines with directive principles of state. When I look and fundamental duties. When I look at the rights under Article 25, social reform or not, in keeping with the directive principles, you will find when you go through it, my lords, I'm not going to take your time. We do not deal at all in the directive principles with gender equality in the access to any place of worship, irrespective of the nature of worship. It is not even an aim to achieve gender equality, while the aim is to achieve gender equality in employment, in other manners. Access to places of worship or freedom of religion does not include this concept of gender equality even in the directive principles. Well, therefore, Article 25(2)(a) deals with particular activities in a religious practice, for example, property. 2(b) deals with the state's power qua particular institutions in the interest of social welfare and reform, although the words used, if you would kindly see, says providing social welfare and reform or the throwing open of Hindu religious institutions, should correctly be read as providing for social welfare and reforms inter alia by throwing open the Hindu religious. It can't be, I can just throw it for no reason. But like your Lordship said, that's a matter to be tested in a given case. Sorry, Malan.
Very difficult to accept this. Because if you accept it, it will still other stuff.
No, I put it in this manner. I am saying, please take the color of throwing open the Hindu religious institutions to the words preceding it. That is, actually, that should be the nature of my submission.
In terms of defining what constitutes social.
Yes. For that purpose, yes, you can throw open an institution, but you throw that institution open for the purpose of social welfares and reforms. That is the manner in which I'd like to interpret 25(2)(b). So it is not an absolute right. It is a right which is certainly circumscribed by the fact that the state can act in a larger good, but when considering the larger good, cannot open out the temple to and say X can go in or Y can go in without going into the question as to whether it is for furtherance of social reform or welfare. That is the submission I want to make to my lords. It has to be read together. It cannot be separated. The two have to be read together. Well, so far as denomination is concerned, much has been said, many judgments written about denomination. Because of the time, I'm not taking my lords to the various interpretations. I've tried to concise my arguments as much as possible. Denomination, basically, like I said, for religion also I gave your lordships what you might feel is too simplistic a meaning. But that is the way we all understand it. Religion is a belief in a superior force. God is the particular God, the deity, the idol, is my personification of that belief. I bring it down to simple terms. Now, denomination, please.
Is there not a fundamental contradiction in the argument if you say that we should be providing for social welfare and reform, inter alia throwing open? The fundamental contradiction would be that providing for social welfare and reform can only be for a limited section also, but here throwing open is for all classes and sections.
Yes. My lord,
social reform and welfare can be limited only to a particular group within a denomination.
Social reform so when you open a religious institution to all classes and sections,
the social reform
you're doing so
can be limited to a particular subsection also, but
yes,
to all classes and sections.
Yes,
it's a blanket. That is like throwing
all or some,
or
include some.
How can it be qualified by?
Maharaj, I read the word all in Article 25(2)(b) to be all including any part of. All is not the whole class. Eliminating. It is a question of all classes and sections. That is to have the right to open it to any class and section which is necessary for social reform. But there again, please, my lords, keep in mind that my submission is classes, sections does not include gender. That is but looking at the words themselves, when I say to all classes and sections, obviously a particular notification of the government, a particular action of the government, a particular law of the government would be pertaining a certain class. It need not be the world at large. It need not be the world at large, but class would mean all those similarly placed will necessarily, otherwise it runs foul of Article 14. So when we say to all classes and sections, all similar classes, but not universal all, that is all or none.
Providing for social welfare and reform, that is not qualified, but throwing open is only restricted to sections of classes of Hindus.
Yes, absolutely.
Reform can be to any religion.
Yes,
that can be made. But this restriction of throwing open is only, that is why it is qualified for sections of Hindus.
Absolutely, which is why the lordship also says
it cannot be read in the same thread.
In which case, my lords, I may explain why. For example, if we take, my lords, Muslim places of worship, my lords, definitely it is not thrown open, and the state throwing it open for access outside the religion may not come up at all. But most institutions, temples, Hindu institutions, I take Sabrimala itself, it is, my lord, religiously Catholic. Any religion, person of any religion can come in. It's not only a Hindu. Provided you do.
No, even in Dargahs and all, everybody can go.
Dargah, yes.
There is absolutely no restriction of anybody.
Dargah, yes, but I'm not sure, my lord, on whether the rule is for all mosques. Dargah, yes.
Different cathedrals have that.
It's only in respect of a mazar. not.
Yes.
When it is a mosque, there is no bar for a woman to enter. It's a mazar.
Not women, my lord. I'm talking about people who do not profess that religion at all. I'm talking about
There
their.
is no bar for.
No, my lord was putting the question to me.
Non-Muslim to enter a mosque. The question is whether they can worship inside.
Inside. That is the point. That is the point. Because if your lordship sees, you're asking me the question on B. Whether the first part of B.
Reverse will apply in respect of a temple. A non-religious, a non-Hindu can definitely enter a temple, but the religious practices may not permit offering of namaz inside the temple.
But your lordship is talking about a mosque, but I'm talking
about just put the reverse.
Yes.
The same injunctions may apply in all religions.
In some temples not so. For example, Sabrimala itself.
Does Sabrimala permit offering of namaz inside the temple?
Not namaz, my lord. The form of worship, which is what I'm coming to.
So the form.
You cannot sit, for example, I can't go to Tirupati when the Suprabhatam is being played and say, I want to sing to the praise of Lord Shiva at that moment. When I go to a temple, I accept the form of worship of that temple. What we are asked today in this case is to see whether I can insist on access,
Sir, your point
changing that form of worship. That is the whole moot question.
point is well taken, but the 25B does not speak of worship, it speaks of entry.
I'm coming there. Manoj, the entry itself can be thrown open today, but the question before your lordship is, if a particular institution says the nature of the deity is such that it belies the entry of a certain person, would the state then come in and say, I'm sorry, you cannot belie the entry of such a person unless the refusal is pernicious. Refusal traces to Article 17. The refusal traces to something which is shocking to the human conscience. And that's why, as my Lord the Chief Justice said, that's a matter which will have to be seen from case to case. But cannot be said as an absolute.
The thrown open part is very clearly is reiteration of 17.
Absolutely.
Replantation of 17.
Absolutely.
Of 17. That part really is not.
That is why I was answering my Lord by saying classes there are similar sections which are of a similar class. You cannot distinguish.
Even sections of the Hindu.
Absolutely. Absolutely.
Therefore, there should not be any mistake that 17, the Constitution declaration and a very powerful right of 17, that has been reiterated with reference to the.
My Lord pleases. In fact, that is, I couldn't put it in any other way, my Lord. That is my submission. My Lords, I am now coming to what is a denomination. My Lord, denomination is nothing more, because we have realized one thing. If a temple is an abode of God, God is my personification of my belief, and that particular God is in a certain form. My denomination is in what manner I wish to offer worship, and to God in what form. It's not that you have to go further into denomination. If I see God in a certain form and in none other, and I see his worship in a certain manner and none other, I form a distinct class from people who see God in another form, or who want to offer worship to him in another form.
It should not be in one form only. It can be in many forms.
That is my choice. Exactly, your ladyship is right. That is my choice. But let us say there's a collective group of us who see him in a particular form and who see a means of offering worship to him in that form, in a common way. We are a denomination. We need not go further by tests of denomination. Is there an institution? Is there a purpose? Etc. We are a group, we are a denomination. And to answer my Lord Justice Bharti's question, what if within the denomination can you not debate? Of course you can debate. On the contrary, you can go one step further. You can say, I'm sorry, a group of this denomination doesn't agree with this form of worship. We have a totally different form of worship. You can form another denomination. that itself will become a denomination. So let us not go into this concept of denomination like a great matter to be legally discussed as to what would legally connote
What you
it.
are saying, denomination is something which is to be left to the collective behavior.
Absolutely.
Don't go into this, that's all. Whatever they do, it's their common belief. Small variation or same thing, whatever we can say, so long as they decide to have a group and they have decided to have faith and practice it profess, they are leaders.
That's why I said, my lord, my attempt is to very simplify the two articles. I know there's a lot of literature on it, but I want to simplify it because we are dealing with 25, 26.
Are collectively managing their affairs.
Absolutely. Malad, therefore, please see the definition I have given, Malad.
You need to have a formal organization as such.
You don't need it.
That's the reason I just say you can't dissect 25 from 26. It's a progression from there. How to it's a next step.
Absolutely.
You become the denomination will become part of 25. Additionally, how to manage in
So the denomination itself is also protected under 25. Not only under 26.
Very common believers or by your own self. Everywhere you will hear that way rights and liability are determined 25.
Absolutely.
So far as belief, practice and purpose is concerned.
In fact,
In
that
terms of management, other things, to administration.
could be different. Manoj, there also owning property could be a secular activity, that is something else. But Manoj, this is why I disagreed with my learned friends who said that 26 excludes 25, because why? See, 25 is an added ammunition for an institution, for a group of people. It's a right to practice a religion. So if I want to practice a religion, I can practice religion in my form of worship, provided it's not pernicious. That's why please see my definition, what I've given to the denomination.
See, propagation of religion can also be a matter of religion.
It is. As your ladyship knows, I can be an atheist and that can still be a freedom of conscience.
Propagation of a religion is also coming under 26B.
Yeah, absolutely. You're absolutely right. Absolutely right. Yes.
It is a matter of religion.
It's a matter of religion. So therefore the two are intertwined. I said 26 cannot be divorced from 25. The two go together.
Your point number 3 has been broadly argued by everyone in the same matter. There is probably
I saw there was a slight digress because there was some arguments taken before your lordships that 26
Does not say subject to
is not covered by.
That will be understood by you.
That I want to dispel that from my side.
No.
That's all my aim.
the point 3 is only with respect to the meaning of denomination.
Yes.
Broadly argued in the same matter.
Point E, I want to say it's nothing more than a collective group who offer worship to God in a matter distinct from others, who have a common religious belief but express their worship in a different way. That is, we all might have a religious belief, common religious belief, we are all Hindus, but we express it in a different way. If we accept that is a denomination,
Up to
I'll come. If we accept that is a denomination, and we accept that 26C, B gives the powers to manage my affairs in a manner of religion, then my form of worship of the deity who reflects my understanding, which is the Nastika Brahmacharya, the question then is not an absolute. Article 14, how are you distinguishing against women? That is not the question. The question says your denomination's manner of worship of a deity in a particular form. Is this exclusion rational? That is the only test.
The issue with respect to administration and management. This public morality it can be only with respect to management and administration.
Absolutely.
Otherwise, you go on to 25.
25.
You will not have any better right than
Which is why my lords will say,
believer or common believer. You are only a manifestation of those persons. That's all.
which is why my F, proposition F, according to me, part 3 will apply to 26 also. Part 3 applies to 26. In fact, F,
There
I
could be
said,
legal deed, but restriction only with the public order, morality, and safety, that's where the problem is. If you come under 26 rupee, 25 rupee, then there is a matter. You can't say it will come under partially, it will come under public order, morality, and health, then other party will not.
I said both are intertwined. That is my submission.
That's
They
it.
are intertwined. But let me explain why.
Is conspicuous by its absence. Otherwise, they could have said subject to part 3. Or they could have said subject to Article 25(2).
My lord, there,
Said in Article 26.
there my answer to your ladyship is this. If 25 gives me the right of freedom of religion, it is a fundamental right of mine, like every other fundamental right. It is tempered by its own restrictions. Like every other fundamental right is tempered by its own restrictions. If I am given the fundamental right of religion, it is my right, which is an individual right, or my right as a collection of individuals, it's our right. So we trace our right to 25. 26 says the state indicates, state will not interfere in the manner of your exercising that right. Subject again to 25(2). So I'm saying you can't divorce 25 and 26. My right, your ladyship will see 26.
That's what Srivastava saying. Your rights are subject to 25 to.
And 26, my right under 26,
Then we got it, we understand, we appreciate it.
my right under 26 is a manifestation of my right under 25.
We appreciate that, we follow it.
And if you, 26 does not provide for any restriction other than public order, morality and health. However, we cannot say that so far as 26 is concerned, 25(2) A and B cannot be applied. It can be. So, my lords, how I ask myself, could anyone try to divorce 25 and 26? You cannot do so. Foundation, the fountainhead of your power is 25, of my right.
Again, please, either you take it or leave it, that's all.
Also, one area where some of you are at variance, you will examine it.
Please, my lord. But I'm giving the reason why I am canvassing it from the angle I am. The reason I'm canvassing it from that
I
angle,
can say is your approach appears to be more balanced than the other.
I would want so, my lord. Whether your lordship thinks so, sir, a different matter. No, the only point I want to make is this. My lords, I also had an argument saying that 25 was individual, whereas 26, no. The right to profess my
We
religion.
understood it fully, no problem. We understood it fully. That's not it.
My lord, these are the broad propositions on which I would like to. I have, my lords, placed an 8 memoir elaborating these. I'm not going to take my lord through it, but I cut short everything in a different way from my original submission, based on much of what I'd heard and much of what I felt I would like to address my lords on. But in short, my lords, what I would like to say is this. In short, what I would like to say to your lordships is this. Number one, classes does not include gender. Number one. My lords, I've given various reasons in my 8 memoir, but I'm just summarizing.
Yes, sir.
Class under 25(2)A deals only with secular activities. The 25(2)A deals only with secular activities, not with theological, not with religious. Article 25(2)B, when referring to classes, does not refer to gender.
That's it.
And therefore the power to throw open for a gender is not traceable to 2B. If at all it is claimed, it can only be claimed on the right of 14, because part 3. But if you take 14, you must see whether there's a rational, intelligible differential, rational reason for it. Now, if you take that reason as being the reason being, it is felt by this people who are worshipping this particular deity, in this particular avatar, in this particular form, that being a Nastika Brahmacharya, this form of worship is called for. And if that is not found totally arbitrary, illogical, perverse, or reprehensible, your lordship would not interfere on a matter of somebody claiming a right because of Article 14. 14 has no role. And finally, the submission which I have to make is that 26B is nothing but an elaboration of a right I am already granted under 25(1). This in short are my submissions.
This is the first point you were saying. That's the first.
I have given an aid memoir. I just want to refer there, my lords, to page 5. My lords, page 4, Roman 3, Roman 4. The pages are at the foot of the page. What is the meaning of the expression sections of Hindu occurring in Article 25(2)B of the Constitution? Article 25(2)B itself, referring to classes and sections of Hindus, has to be kept in reading in mind with Article 17, cannot be taken as encompassing gender, especially since Article 25(2)B refers to Hindus, includes offshoots of the same and not to other religions. Because your lordships will see the explanation included Jains, Buddhists, Sikhs, Buddhists, which are offshoots of the Hinduism itself, and not to other religions, which makes it clear that classes referred to therein as is contemplated in Article 17 and in juxtaposition to Articles 15(2), 16(2), where there is an intention to include gender, it is specifically mentioned. Sections of Hindu is only used in the context of Article 25(2)B, being Hindu religious institutions. Concept of gender would be part of 25 as a whole and not to 25(2)B. The intention of the makers of the Constitution cannot be presumed to ensure gender equality in the context of Hindu religious institutions, to the exclusion of all other religions and their institutions. Your lordships will find I'm supporting this with this. Wherever gender equality is called for, there are specific articles dealing with it. My Lord Justice Bagchi said directive principles. Please see, in directive principles, Article 38, 39, deal with gender equality, but where? In providing employment in those areas.
So that's applicable for everybody.
So gender
across the board.
Across the board. So gender equality is not taken particular to a manner of worship. So gender equality is not an integral part of a manner of worship. Absolutely. So my whole point is, gender equality, while as a notion, is something which is to be furthered. Where it is required to be furthered, is specifically provided for. Otherwise, it is not an integral part of that religion. If it's not a part of that religion and it is a rational manner of distinction, the courts would not impose Article 14, which is exactly what has been done earlier. The whole genesis of the earlier case, if you look through it as a thread, it's Article 14 is the thread of the entire judgment. Whereas it is my submission, Article 14 has no relevance here. That is my submission. Now, please see, I dealt in Roman 4, and I conclude with this, Manas. I realize that I did say I'd finished. Roman 4, interplay of Articles 25 and 26.
So actually the arguments are coming up with what you are totally your point now. See, this again is, you started with this only.
Yes.
That's right. You can note it down, that's all. No,
Absolutely. So, Manas, I will conclude it with this.
Yes.
That neither Article 21 or 14 would have any dealing with it. When your lordships have the time, please see my note on it, but I didn't want to take more time. You've heard enough. But I wanted to highlight these were the aspects of it. Sorry? Which is this?